Welcome to the Talk with Clads podcast. Your host is Katie Ann, an island girl on a journey with her guests to learn about their backgrounds, businesses, passions, experiences, life lessons, and wins. Come and laugh, cheer, learn, and plan with us. My friend, take some time to come and talk with Clads.
Clads Resources and Consulting values its customers. Our planner Footsteps to My Vision is a 13-month planner that can be used for 5 years. It walks you through SMART goals, SWOT analysis, action planning, and holds you accountable through 3 monthly check-ins. We work only with top quality materials, innovative designs, and verified suppliers, which are guaranteed to deliver to our high expectations, because when it comes to our customer satisfaction, there's no room for compromise. Made with high-quality PU leather and paper planner helps you focus on achieving your goals by giving you a sense of personal and professional satisfaction. Some of the amazing features of this product: Vision Board Planner, Luxury Pen, 8GB USB flash drive, wireless mouse, ultra elegant packaging box, available in 5 stunning colors: black, red, gold, pink, navy blue. Material: PU leather. 13-month planner. Elastic band for easy handling. Our Footsteps to My Vision is available at Amazon, Facebook, Instagram, our website, and at Walmart. You may also follow us at www.cladsresources.com, Instagram, Clads Resources, Facebook, www.facebook.com/cladsresources/.
Hello, world. Welcome to Talk with Clads. My name is Katie Ann, and I'll be your host for today. We have a special guest in the house. We have Attorney Taniquea Reid of Law Office of Taniquea Reid. Taniquea, welcome, welcome, welcome.
Yes, thank you so much for having me. I'm excited to be here.
Okay. So we are going to discuss an area of law that you practice, which is probate.
Yes.
So what is probate?
Well, probate is essentially a supervised process where the court gets involved, and essentially the assets of a deceased person is marshaled, meaning gathered together, and distributed to the beneficiaries, and the debts of the decedents are paid.
Okay.
So essentially, it's where you pass legal title from a deceased person to someone else if the deceased person did not have probate avoidance methods in place prior
Okay.
to death.
So who is typically involved in the probate process?
Typically, it's going to be a beneficiary or an heir of some type,
Okay.
meaning that comes in all different forms, right? So it can be the spouse of the deceased person, it can be the children of the deceased person, it could be brothers and sisters if the person has no spouse, no children, it could be parents of the deceased person. Really and truly, it could also be, who knows, it could just be a friend
Okay.
or
So
charity.
can you have a will in probate?
Yes, you can certainly have a will in probate. Some wills definitely are structured in such a way that it avoids probate, but sometimes that is not the case, especially when the deceased person have other assets that may not have been included in the will.
Okay. So what's the difference? Because I sometimes I hear the word will and I hear revocable living trust. So what's the difference between like a will and a revocable living trust?
Well, really, a revocable living trust is something that is created for the benefit of the person who creates it, right? So you
Right.
have the revocable living trust of Taniquea Reid, and that's something that will shield me in case of incapacity as well as death. It can assist in incapacity as well as death, whereas a will is solely in the case of I'm dead and gone.
Okay.
But keep in mind that a revocable living trust, it doesn't have the tax tax avoidance mechanism as, say, a revocable living trust, an irrevocable living trust might have, or other type of tax savings, and things like that. But people tend to put it in there so they don't necessarily hold the asset in their own name. It's held in the name of the trust.
Okay.
And it does help to pass assets along in case you're deceased.
And when we use the word trust, what are we addressing?
You can put almost anything inside of a trust. You can put your property in it. You can put your stocks in it. Whatever it is that things that don't have beneficiaries assigned. So you can't put don't put your life insurance in it because you might just name, unless it's a life insurance kind of trust, right? But if you have things that already have assigned beneficiaries under there, like your 401k, then you wouldn't put that in there. But again, your vehicle, your house, your land, things like that can go into a trust.
Okay. So when someone passes, right, how is the executor of the estate? Because you watch TV sometimes and say the executor of the estate. So how is that determined?
Multiple ways. So the executor is going to be the same thing as a testatrix.
As the what?
Not testatrix. Yeah.
Testatrix. Can you use it in a sentence, please?
Yes, I'm the testatrix of your estate. So they're interchangeable.
Hold on, break down testatrix. I don't want to say the wrong thing. Testatrix. Yes, break down testatrix.
It's going to be the same. Again, it's going to be interchangeable with the executor of somebody's estate as well as the personal representative. So it's the person who is now in charge. Once a decedent has passed, that person is in charge of marshaling the estate. So they're the one who will file whatever. Well, the attorney will file it, right? So somebody will get nominated. Sometimes you can have more than one if you so choose.
So who nominates the person?
If there's a will, then the person who was living at the time would put in his or her will who he would want to act as
the testatrix,
the executor, yes, a representative of the estate. And by law, Florida law, once somebody passes, the spouse has priority, and then the lineal descendants also have priority to act as the personal representative. But if those people are unable to do it or unwilling to do it, anyone can be a personal representative so long as the majority of the majority of the beneficiaries consent.
Okay. So can you inherit debt when someone passes?
Oh, that's a good question. And the answer is it depends. So it's yes and no, right? And I say no in the sense of if I hold debt in my own name. While I was living, I went down to Wells Fargo and I borrowed a line of credit, right? It's only held by me. If I pass away and my daughter, just pretend she's an adult, right?
Right.
Zamaya is now going through the probate process. She's not going to inherit my debt because that debt was held by me in my name.
Right.
Now, if I have assets that the creditor can come after, then they'll be able to come after it. But Zamaya is not personally responsible for my debt.
So they can sue the estate for the
Correct. They make a claim against the estate. But I say it depends, right? Because think about it. If Zamaya and I hold property together as joint tenants, right, and there's a mortgage on the property, she's, and I pass away, she's going to benefit from the mortgage on the property, right? So the mortgage tends to run, it's going to go with the property. So in that sense, I loosely say, yes, she can inherit the debt. It's not really inheriting because it's attached to her property. Okay. But if you want to look at it that way, you could.
Okay. So going back to the debt, does it carry an expiration date or? So let's say Zamaya is underage and the creditor wants to sue the estate. Can they still sue the estate or do they have to wait, or can you even probate with minors?
Absolutely. Somebody has to act as a minor. Somebody has to act as guardian of the property for the minor. So somebody's going to have to step in, right? And act as a personal representative, of the estate.
Right.
Because somebody's going to have to get that process moving. So what they will do is they'll let the court know that a minor is a beneficiary. So what will happen, that's going to be a twofold process. You'll have the estate side of things going where the personal representative, again, is getting the process going of marshaling the assets, settling things with creditors if they can, or really borrowing,
Yeah.
moving the assets around so creditors can't get access to it because certain things are exempt. Homestead is exempt, a vehicle might
Okay.
be exempt, furnishing, family allowance might be exempt. So there are different tools and mechanisms that can be utilized that will circumvent certain claims by certain creditors. Um, in the case of where my daughter is a minor, she's going to have some type of guardian, right? So somebody is going to have to come in and act as a guardian of property over minor. So on that side of things, they're asking the court to establish a restricted bank account that would then move the assets from the estate side of things into an account for her until she turns 18 or whatever other what do you call those things? Whatever other, you can do annuities, you can do saving strategies until she turns 18.
Okay. All right. So earlier you mentioned sometimes the spouse can be um, the testatrix.
Yeah, it's a personal representative. You just like that word, right?
So they can be the personal representative. So like, how does probate affect community property?
Well, when you say community, do you mean as in the case of a husband and a wife?
Right.
Okay. So in the case of a husband and wife, if they own it jointly, you don't always have to go to probate for that. Because if my husband and I own property and he dies, there are certain things, certain times you can file a paperwork that indicates to the state, hey, one owner has passed away, retitle this property in my name only, right? So if it's something as simple as that, you can skip the probate line and just go about it like that. And that might also be possible for vehicles. However, in other situations, you might have to go through the similar probate process. For example, when we are husband and wife, we pay the bills together, we using air quotes here, own the home together, but my name is not on the title.
Right.
Because my name is not on the title, then yeah, I'm going to have to go through the probate process. Because again, I'm legally trying to shift the title of the property that belonged to the deceased spouse into my name.
Okay. All right. And sometimes I'm sure that can get a bit dirty if other people try to step in. No?
Absolutely. Absolutely. Especially when you have cases where it's a second marriage or, the person who is deceased had children from a prior relationship and the children and the spouse don't get along. Of course it can get nasty. But it can also be, a peaceful process. So
Okay.
it depends.
So based on your experience, how peaceful is probate typically?
Oh, Lord. In all honesty, I would say most of the time it's not nasty.
Okay.
But when it is, it is. When it is, it is. And it gets spicy, but I tend to see that more when people have a ton of money. The fight definitely drags on and you have a bunch of different attorneys claiming. And it's unfortunate because sometimes it's the attorneys and the curators who make money off of the property and not you,
Right.
not you, the beneficiary who may need it.
Okay. So a lot of times as businesses, right, was it sole proprietor?
Mm-hmm.
Like we're our one and only LLC
Mm-hmm.
and we don't have partners. So what happens to a business during the probate process if it's not a partnership?
Well, if it's not a partnership, and well, if it's a situation where you're passing it down, right? So you're passing it down to your son, then of course somebody steps in and takes over. However, if it's a business where nobody is taking over, then that business is going to have to be dissolved. So whether it's going to be administratively dissolved by the state because people stop filing their annual report, and stop paying all those local business taxes that they get assessed, or and in that, or it closes for some other reason, then you have to wrap up the accounting in the business, and sometimes that involves monies that are in there that need to come into this estate. So you're gonna have to, one process could be you filing a petition with the court to pull those assets from that now dead business or dissolved business and pour it into the estate so it can be distributed to the beneficiaries.
Okay. So how do you see probate affecting minority communities?
Listen, probate affects minorities just as much as it affects anybody else. It's just sometimes people, it really is. I take that back. It affects us more in there's more of a disadvantage to us than other communities, because people sometimes don't have the money to go through the process, and when they can't find the money to go ahead and move title from that deceased person's name into their own name, then what happens is sometimes they no longer are paying the taxes, and the buildings go get dilapidated, and then the state takes over. So probate really, it really is important for generational wealth, to really be able to either A, when the person is alive, spend the time to go through their assets and make the appropriate preparation, whether it's via a trust, whether it's retitling property, because sometimes it's as simple as, if all you own is a house and you have one child, then retitle the name of the house, the title of the house, excuse me, and put it in the name of, again, I'll use my daughter, Tanika, Reid, and Zamaya as joint tenants with rights of survivorship. That means if I pass, then it automatically goes over to her. So then she avoids a probate process. Or sometimes, again, it's just you making a will
Right.
that passes property from you when you're deceased to somebody else. But too often we leave the property there and we don't go through the proper channels. So no, we can't sell it, right? Because people want clear title.
Right.
So it's impossible to sell, and you don't have enough money to do it. So you're just stuck in this kind of a weird little cycle, and oftentimes end up losing any property that you could have preserved for generational wealth.
So when is probate not necessary? When you have a will in place?
Or a trust.
Okay.
So, or again, other probate avoidance things, such as, again, I just talked about the fact that you can retitle a property with joint tenants, in a title as joint tenants with rights of survivorship.
So does an asset have to be a certain amount to go into probate? Like if you only have like a bank account with, like, let's say $5,000, and you leave no survivorship or tech trick or whatever.
If you use no beneficiary, in that case, it's a beneficiary. No, that's fine. You any amount of money, because you don't want the bank to get it. $5,000 is a lot of money. Yeah, it's not nothing to sneeze at. So you do want somebody to, you do want to go in there and move that money from Bank of America. I'm just going to use them
Right.
generically to your beneficiary.
Clad's Resources and Consulting values its customers. Our planner Footsteps to My Vision is a 13-month planner that can be used for 5 years. It walks you through SMART goals, SWOT analysis, action planning, and holds you accountable through 3 monthly check-ins. We work only with top quality materials, innovative designs, and verified suppliers, which are guaranteed to deliver to our high expectations, because when it comes to our customer satisfaction, there's no room for compromise. Made with high-quality PU leather and paper planner helps you focus on achieving your goals by giving you a sense of personal and professional satisfaction. Some of the amazing features of this product: Vision Board Planner, luxury pen, 8GB USB flash drive, wireless mouse, ultra elegant packaging box, available in 5 stunning colors: black, red, gold, pink, navy blue. Material: PU leather. 13-month planner. Elastic band for easy handling. Our Footsteps to My Vision is available at Amazon, Facebook, Instagram, our website, and at Walmart. You may also follow us at www.cladsresources.com, Instagram, Clads Resources, Facebook, www.facebook.com/cladsresources/.
You're listening to Talk with Clads. Find more resources online at cladsresources.com. Now back to the show with your host, Katie Ann.
I go back to my hourly rate.
Okay. And you do practice probate?
I do.
I do. So typically, what is your process?
For summary, like I said, for summary, I will definitely do a flat fee. But if it's formal, because formal, you never know what you're getting, right? Because formal is when you're really trying to find out who the beneficiaries are. And that's when you're going to find out whether or not they're in agreement, right?
Right.
Who's going to contest, who's going to not contest. That I charge for on an hourly basis.
Okay. All right. And in what's now to the gems, like, well, what are some gems that you'd like to share with our listeners about the probate process and the importance of having a will?
Okay, estate planning. I think holistic estate planning is the right way to do things, because you want to, when you have control over your money while you're alive, and it also, with proper estate planning, it allows you to retain some of that control from the grave, right? So, of course, if you're a control freak, I'm sure that's appealing, but it really does help give your loved ones peace of mind.
Right.
So they know what you want them to do with your stuff when you are no longer here. And it shows them that you cared enough about them and the process to really take the time to plan things out. It's also a heck of a lot cheaper doing it that way,
Right.
Spend the time to go to a professional. I know sometimes we just don't think it's worth it, but it really is. Yeah, estate planning is one of the best ways to build and retain generational wealth. And it's also one of the best ways to care for children turning, from a minor going to an adult. If you die and you have this substantial life insurance policy, you don't necessarily want your 18 or 19-year-old waking up one morning with access to 250 or $500,000. That person might not have the good sense to spend it responsibly. And it might also hinder that person from getting scholarships and financial aid for college. So, proper estate planning crosses multiple fields. And it's very, very important. And when I say holistic, I don't just mean you need to write up a will. A will is wonderful. But I'm also talking about, a healthcare surrogate. I'm also talking about a living will that tells people, whether or not you want a DNR.
But what is, a lot of people don't know what a healthcare surrogate is. I think at times, we may find it difficult to have the end of life conversations with our loved ones. So can you say what exactly is a living will?
Well, that's pretty much what, it's you telling people what you want them to do when you're incapacitated. So it's not the most comfortable conversation. It is painful, and it is, I'd say that, sometimes it's awkward, telling somebody, hey, if I crash, right, if I'm in the hospital and my vitals are failing, I don't want any feeding tubes. I don't want any life-saving mechanisms to be performed on me. I don't want to go in a ventilator. It is a difficult conversation to have, but it's very, very necessary.
Yeah.
And you want to choose the right person who will make that decision, because the worst thing in the world is to choose somebody in the moment and then they're unable to make that decision.
And I've been witness to that, where someone was made a healthcare surrogate, and when it was time to make the decisions for what that person wanted, they couldn't do it.
Exactly.
They could not do it. And it ended up in a legal fight.
There you go. Yeah, you don't want to surprise somebody with that. Just like how you don't want to surprise somebody like, ta-da, I have died. Now you have my 5-year-old. Certain things you
There's a 5-year-old come with $10 million.
Right. I mean, even if the 5-year-old does, you need to have the right person in place and in full agreement with these things. It should never be something where the person is surprised. Because you do want your wishes respected, and you do want this person to feel comfortable making those types of decisions for you and to be strong enough to do it.
Yes, I agree on that based on experience. So one of the things that I always ask is, will a will stand the test of time, right? So if a will is 30 years old, will it stand the... So does a will, of 30 years, how relevant is that to the beneficiaries?
Well, a will technically has no expiration date, right? A will becomes revoked. You can revoke a will if the person who made a will took active steps to revoke the will. If they destroy the will, if they did something in writing revoking the will, or if they did different, if they wrote a brand new will that contradicts it, then obviously it's clear that their intent was to revoke the former will. But just because a will might be a certain age, in terms of how long ago it was created, doesn't mean that it's no longer good and effective. If the property is still there, then it can still pass along, and there's no newer will voiding it, then it's still good. However, I will share that I had a probate case where the mom had the decedent did a will, but the notary section no longer complied with Florida law.
Oh, wow.
So the notary section, whether it is, I think this one might have just been some will packet they picked up offline, so it wasn't the best. And of course, when I filed it with the courthouse, the court nicely notified me that, in essence, my matter was an intestate, meaning the will was no good.
Oh, wow. And the person already dead.
The person died. Lucky in that situation, it was only one child. The person only had one child, so the daughter got everything that she needed to get anyways.
So did that go into probate?
What, the will itself?
Because it was no longer valid.
No, the will, the court rejected it. It did not comply with Florida law anymore.
Yeah, so if it didn't comply, then does that mean that the property then would have gone into probate?
Correct. So
okay.
You have to do it as intestate. So sorry.
All right, stop using big words.
Yes.
Oh my word.
Stop it. So testate is when a decedent has passed away with a will. So they die having a will. Intestate is when they do not have a will. So that example that I gave, it went from a testate situation, meaning they had a will, to where the court found that the will did not comply. So it was now I had to redo the paperwork and now make it an intestate situation.
Okay. So we learned intestate, testate. So Taniquea, how can our listeners contact you? Because you do property
damage claims and litigation. So if you have any issues with your insurance company and you need to make a claim against your home or your property that you have, yes, you can contact me. I do probate. I do guardianship work. I do estate planning, and I do some elder law as well. People can contact me. You can look me up, Law Office of Taniquea C. Reid. And my website is treidlaw. So TREIDLAW.com. My phone number is 561-316-6241.
Okay. And can you repeat your phone number one more time?
561-316-6241. And I have like a really nice and catchy one as well. It's 1-866-4411-LAW, which is 529.
Okay. So repeat the last one, the catchy one.
1-866-4411-LAW, and law is 529.
Okay. Well, thank you so much for coming and dropping some gems and knowledge about probate, the importance of wills and trusts, especially along the minority community. This audience is not only minority, but sometimes as a minority, some things affect us a little bit more than another group. So I'm not trying to segregate one group, but I'm just saying, perk your ears a little bit more sometimes, because sometimes we'll get the knowledge, but we'll do nothing about it. So your legal eagle, you know what I mean? So thank you so much for coming on Talk with Clads and just sharing this information. And thank you again for taking some time to.
Yes, thank you so much. Yes, it's funny that you say it. You're right. We're not necessarily trying to just base our audience on a minority section, but I have a strong I want to strongly encourage my fellow brown skin and dark skin people to do it, because in my profession, we do find that our Caucasian brothers and sisters overall tend to have their affairs in order prior to passing away.
Right. And it goes from one generation to the other. I think they definitely plan a little bit better than us sometimes.
Correct. And, being from Jamaica, I used to think, oh my gosh, it's just Caribbean people, but it's not. It's not Caribbean people. It's not just Africa, and it's not local to just Florida. Several months ago, I was watching something, and I cannot remember what state, but they were showing all this row of houses, this community where the houses are a little bit run down. And the problem in that community was that people, once somebody had died, were having difficulty transferring the assets into their own name, getting through the probate because they didn't have the money to do it.
Oh.
And as a result of that, they couldn't get clear title to sell, so the houses were just stuck essentially.
Wow.
So it's not just a Florida problem. It's not just a Jamaican or Caribbean community problem, and it's something that we need to address.
Yes, yes, yes. So thank you so much for addressing it. And thank you for taking the time to talk with Clads. Bye, guys.
Thanks for listening. Find us on social media at Clads Resources and online at www.cladsresources.com. Our planner, Footsteps to My Vision, is also located on our website or on Facebook, Instagram, or Amazon. Don't forget to like, subscribe, and share, and check back weekly for new episodes. Until next time, keep creating your footpath to your vision.